Good evening, everybody. I hope you are all doing well. Jonathan Ginsberg here. It is March 18th, 2026. I hope everybody is again doing well. Looks like the last gasp of winter here in the Atlanta area. It was pretty cold, like freezing last night. Today was in the 50s. I think tomorrow is going to be warmer. By this weekend, it's going to be in the 80s. I'm supposed to play a tennis match on Saturday, and it's supposed to be in the 80s. So it's going to be kind of warm, but I kind of prefer that personally to the cold. So again, I hope where you're at. I know the Northeast has had some crazy weather. Anybody who's flying, I know that's a real issue. I have some friends of mine who were flying over the last week, and with the government shutdown, the TSA agents not getting paid, a bit of an issue. So I hope that wherever you're at, you're not dealing with all that kind of nonsense. Obviously, gas prices are a very big deal, and I think it's going to obviously cause a lot of hardship for people on disability or people who are not working when all of a sudden their fuel costs go up by, double or 1.5%, 75% or whatever. So again, I hope everybody's doing well. I don't drive that much, so I really try to avoid going places I don't need to go, and everything's pretty virtual now in the disability practice. But I know it does cause a lot of stress for a lot of people, and I feel for you, because if I had to drive 30, 45 minutes a day, it would be a real problem for me, for anybody. Let us go to the questions here. Stephanie Alford, she asked a question last week and only half answered. I do hold my credits, but on SSI, not SSDI. How does it happen? And they said it wasn't right. So I would say, Stephanie, the first question I would ask, but I do have an appointment on the 14th. She says, what should I do or say? Well, I think the real question here is to find out your date first insured for SSDI or Title II disability, and your date last insured for Title II disability. And your onset date for disability needs to be between those dates. People sometimes, I've seen situations where people are found disabled during a period of time when they were not yet insured, didn't have enough credits, or they'd run out of credits. So what you have to find out is, was your onset date one where you should have been insured, or you were insured? And the second point I would make would be, you should ask them to treat your SSI application like an SSDI application. The point I'm making is, you say to them, look, I contacted Social Security, said I wanted to file for disability. They only pursued SSI. I relied on what the staff person did, and that's not fair. They told me incorrectly. I should have been approved for should have been applying for SSDI. I want to retroactively file an SSDI application. If you don't get anywhere with the person there at Social Security, then I would contact your U.S. Senator, because there is some law out there that says that when you contact Social Security and you ask about disability, SSA agency has an affirmative duty to make you aware of all the programs to which you might be available. And if they don't do that, they can't come back later and say you didn't apply for the right one. People don't necessarily know, whether you're insured or not. It's not clear at all from even my Social Security statement. So, but that's what I would do. I would first of all say that, look, when I applied, I said I wanted to apply for disability. I need to, if I'm eligible for it, I was found disabled during the time period where I was insured. You need to pursue, or you need to qualify me for SSDI, and that's what I would tell them. And that that your understanding is that there is law that says that my communication with Social Security is a de facto application. There's law that says if you contact them just to ask about disability, that can count as an application. The courts are very generous in finding that a non-attorney would not necessarily know what to exactly ask for, and by contacting them, you are in fact asking for all the benefits to which you might be entitled. So that's what I would tell them, but that's the argument. But I think the questions to ask, again, to recap: when were you first insured? When were you last insured? And during the time you communicated with them, they need to treat that as if it was an application. Will they go ahead and do that retroactively? If you don't get anywhere with that, contact your U.S. Senator. So I hope that helps. Kevin Johnson doesn't see a diary date on his award or fully favored decision, 60 years old, approved January of 2026. Yeah, usually on the decisions, and I read them all the time, it's very rare that you see a diary date. Every once in a while, you'll see where a judge has put on there, this case needs to be reviewed in 12 months or 18 months. That's usually because the medical record indicates that there is a surgery coming up or a procedure that might make a person not disabled, might eliminate the disability. Otherwise, Social Security codes it internally. And I will tell you that a 60-year-old, given that you're very close to retirement age, 5 or 6 years from retirement age, generally those cases are coded as being improvement not likely, and you'll not be reviewed. The caveat, the one thing I would tell you is recently Social Security changed its procedure for doing reviews, and it's being centralized. It used to be done locally. Now they're doing it in a centralized office. So we may see some changes about the number of cases being reviewed. I know that Congress is very, is pushing Social Security to review more cases. Excuse me. There is this perception that there's a ton of fraud, so we may see more reviews. Haven't seen it yet, but I still think a 55, 60-year-old is not the person who is likely to be found not disabled. Realize that, if you're reviewed at 60, even if you were not found disabled under the grid rules, let's say you were found disabled at age 40, where the grid rules did not apply. Now you're 60. Of course, I know you were found disabled just recently, but let's say that you were found disabled at age 40. If you're in a CDR, you can argue the grid rules now because they're looking at your age now when they're doing the CDR. So at age 60, the grid rule I would look at, and my website for the grid rules is grid rules, GRIDRULES, gridrules.net. I think I've got a link up here. There we go. That is the link, gridrules.net. And if you look at grid rule 202.06, which is the grid rule for light, what that says is that even if you could do light work is defined as standing and walking 6 hours a day, lifting 20 pounds occasionally, 10 pounds frequently. Even if you could do that, you are still considered disabled, assuming no transferable skills. And at age 60, in order for a skill to be transferable, there needs to be what is called a minimum vocational adjustment. So not only do you meet the grid rule, but you meet the minimum vocational adjustment standard. Very, very difficult for Social Security to show that a person who qualifies under the grid rule would have an easy transfer of skills to something lighter. That's a real sweet spot. So anybody pursuing disability or being reviewed over age 60, if it's a physical limitation, realize the grids only apply to physical limitations. You have the grid rule, the 202 grid rules, the light grid rules, and you have the PALMS regulation, which has to do with the transferability of skills. And basically it says there needs to be a minimum vocational adjustment. So the odds of Social Security successfully reviewing and terminating you are very, very low. And they know that. And in fact, if you got in front of a judge, most judges realize that, a 60-year-old with significant medical issues, it's going to be hard for that person to rejoin the workplace anyway. My point here is, I'm not saying it's impossible, but the odds of you being reviewed and terminated are very, very small. As such, you don't see a lot of reviews for people over age 60. So, Kevin, I'm not going to tell you it's not going to happen. I'm just going to tell you it's very, very unlikely. So I think you're probably in pretty good shape as far as that's concerned. So I wouldn't worry about it. I would continue to go to the doctor as you need to. You want to show ongoing treatment. That's the one area where people get in trouble with continuing reviews. And, if you do try to work, just be very aware of the substantial gainful activity figure and the trial work period figure. Probably best not to even try. I hate to say it that way, but that's less problems for you. But again, if you do, just be aware of the substantial gainful activity and the trial work period. Stay below those numbers and you should be just fine. Okay. We have Friendless Foe. I have a TBI, traumatic brain injury, had multiple brain surgeries when you were an infant, have a severe learning disability, have memory lapses, and applied for SSDI. I got denied the first time. This is the second time trying. Is there any grounding evidence I can provide? A neurology report from the evaluation. Um, I would say this, a neuropsych evaluation would probably be stronger because, neurology, and again, neurology is relevant because it's an organic problem. You had a traumatic brain injury, but with the neuropsych evaluation, maybe that's what we're talking about, discusses both the underlying medical issue, changes to your brain tissue, as well as the psychological implications of that. Um, so I think a neuropsych evaluation would be very helpful. I think you want to really focus on the symptoms. And if you were able to work up until a certain point, what changed? I think a lot of times when people are pursuing cases for TBIs and they were able to work, the Social Security is going to say, well, okay, what has changed? And maybe it was that you had a special, unique circumstance where the boss was very understanding, a friend or a relative, something like that. Now a new boss came in and you got terminated. Maybe your symptoms have taken a turn for the worse for whatever reason. But I think you need to really, really focus on the specific functional issues, memory problems. And here's another place where you might ask a third party. It could be a former coworker, could be a former boss, it could be a friend, a pastor, somebody like that who knows you, who can talk about the memory loss, maybe mood swings, anger control issues. These are all things that would impact you in a work environment. Realize Social Security disability is not about the diagnosis. You had a TBI, that's a diagnosis. They don't assume anything as far as what the practical issues are. But memory loss, obviously, mood swings, difficulty maintaining a schedule, emotional instability. There's a lot of things that could arise from a TBI. Again, anger control, I see that a lot. And I think that, at the state agency level, when you file your application, it goes to the DDS or DAS part of the state, Disability Adjudication Office in the state where you live. And those people may not be familiar with TBIs and the impacts of them. Judging somebody's memory loss and how it affects their ability to work, or judging their emotional stability, that's very hard to do. There's not like you can take an MRI of the brain and see, okay, this means that you are, emotionally not stable anymore. It doesn't work that way. It's got to have to rely on what the doctors say. And so many times adjudicators will look at those records and say, there's not enough here to convince me that this person clearly cannot work. You get in front of a judge is going to look at it more holistically. What are all the practical issues? But again, you've got to build your case. Like I said, I think that having third-party statements can be very helpful. Neuropsych report can be very helpful. If you're on medication side effects, medical reports discussing the problems you've got. You just got to build a case kind of creatively, but don't be upset or concerned that the state agency didn't approve you. They deny a lot of cases. I mean, percentage of cases that are approved, not very great, much higher, it's double the rate of approval at a hearing. And a lot of the ones approved earlier, people with, terminal cancer, severe Parkinson's, ALS, things like that. So don't be upset about that. I mean, I try 4 or 5 cases a week. Every one of those cases has been turned down twice. Yet we win most of them because the medical evidence is strong enough and the judge is going to look at it a little more holistically. So, and I think, and I would also just in closing, I would say, don't forego talking about the physical issues. If you had a TBI and you don't have good balance, that may limit you as far as your physical capacity. Realize that light work requires you to be on your feet 6 hours a day, lift 20 pounds. Even if you have the strength, but you don't have the balance, or you tend to drop things, or you may have episodes where you maybe just forget you're holding something. You could even make a physical argument beyond just the TBI elements, the memory and the non-exertional type of things. But you could argue that a person with a severe TBI, problems with balance and memory, can't be on ladders, ropes, and scaffolds, can't be driving a forklift, driving dangerous things. You can eliminate physical jobs as well. And maybe if there's an injury on one side of your body, your left or your right arm is weaker than the other, That could also be a factor where you get the physical part of it into it. Now you can get into the grid rules if you're over age 50. So you can get real creative with this. But I think the main thing I would tell you is focus on the functional, practical limitations that prevent you from being a reliable employee. Okay. Michael Armenta. You've got Lindsay Osterhout as your attorney. Lindsay is a good friend of mine. She's a very good attorney, and you're in great hands. Osterhout Berger, which is her firm, I do a lot of work with them. Whenever I have an appeal that goes to the appeals council or district court, I typically run it by Carl. Osterhout Berger is also on Osterhout. I think they're not together anymore, but they still work together, which is kind of cool. But Carl is an excellent appellate lawyer, and Lindsay's an excellent hearing lawyer. But they do a lot of really good work. And the nice thing about this practice area is attorneys who do this work, most of them or us are willing to cooperate with each other. So if I have a question about something I don't know, I may get on the phone and call Lindsay. I may call Hannelore Merritt, who's in their firm, or I'll call Carl, and they're always willing to share their knowledge. Brian Konoski is another one, always willing to share his knowledge. And so there's a listserv, the NOSCR listserv. People are always willing to share what they know. Somebody emailed me today, in fact, what do you think about this? They were asking me. Always happy to share that information. So Lindsay is really, really good. Reconsiderations, yes, they are more or less rubber stamped. But yeah, if you got in front of an adjudicator who asked for another form and activities of daily living, and you basically filled it out, and you really focused on the practical issues like I was just talking about before, that could bode well. I do see a number of cases approved in my office at initial or recon. It does happen, I'd say 15% of the time. And I think, you talked about the treatment gaps. I think it is good that the adjudicator is working the file. Some adjudicators, are really focused on trying to do the right thing. And I think that it is a good thing. And I'm sure that Lindsay feels the same way, that, if you have an adjudicator asking for more information, that means they're open to the idea of possibly approving you. So that's a really good thing. In fact, I would even go far as to say to people that if you're in a case and you're at reconsideration and something has changed, or you do some, your own due diligence, and you realize that the form you filled out, activities of daily living or disability report or pain questionnaire, was not done right the first time, there's nothing that says you can't fill it out again and send it in, because that's evidence and they've got to consider it. So don't hesitate to do that. But yes, you're in very good hands. Lindsay is great. She's been on the live stream with me a few times. And again, she's one of my go-to resources for information, because she's done lots and lots of hearings, and I think very, very highly of her. So you're in great hands. Christy, how are you doing? How are you doing with this cold? Yes, it's not too bad. I do, I'm not a big fan of the cold weather, and February was just a miserably cold month here in Atlanta. I mean, January and February, and I think I've told y'all I play tennis year round, through like a USTA type of league, and mixed doubles season goes from January to mid-March, and I'm the captain. I don't know why I'm the captain, but I am, and so I have to, make up the teams and schedule the matches and all that. And so what would happen would we have these days where on a Sunday it would be 28 degrees and and drizzling, and so of course you couldn't play the matches. So then I've got to arrange all the during the week, and it was just miserable. Then you'd play at night during the week when it's 35 degrees. Wasn't a whole lot better. So I am, for one, not at all unhappy to see the March come into the calendar and eliminate some of this cold weather. I'm not a fan of cold weather at all. I don't mind the heat as much. Again, I'm from Atlanta, so I grew up kind of with the heat. I don't really mind heat. I'll go out, you take a walk if it's 95 degrees, just never really bothered me. Some people hate the heat. It doesn't really bother me. My dog doesn't like the heat. So she'll like lie down in the middle of a walk, but I don't really mind it as much if you're dressed appropriately. Obviously fluid intake's a big deal. So I'm ready for the cold to be over. But yes, Christy, I am definitely ready for that cold to be over. Martin is shots. Hi. You appealed your SSDI, filed in September of 2024, denied in February of 25, appealed March of 25, still waiting. 61 years old. My congressional rep has now sent a letter. Will this help me win? No, it will help speed up the process. That is called a congressional inquiry. Congressional inquiry. So when you contact your member of Congress or your senator, they will contact Social Security and say, I've got a constituent who's been waiting for a year. What's going on? And I've heard it from the people, the heads of adjudication offices, the senior people, that when they get a congressional inquiry, they will move on it. So that will get you moved to the front of the line. I feel like, the appropriate time frame for getting a case determined used to be 3 or 4 months. Now it's 5, 6, even 7 months. So I don't necessarily tell people to go for the congressional inquiry at 4 months. I would say wait 5 months or so, 5 or 6 months. And then at that point, you can say, I've been waiting for half a year. This is too long, and this is causing a lot of suffering. I would definitely look into doing that. So I think that is, that's how I would do it. But I think you've done the right thing. I would say, because I look at the files when I'm doing my hearings, probably 75 or 80% of my clients I've told to do that, and they've done it, and we get our hearings. And again, it still could be a year and a half, 2 years in, but it's better than 3 years. So you got to be your own advocate. Okay. Yes, we do. Karen, I've got your delayed paperwork. How do you personally call a caseworker as soon as they're looking progressing or able to do so? I have done that. The issue you run into is getting through. I've called adjudicators, left untold numbers of messages, and they don't call back. What I find works better is, typically if you look at your letters, there will be a phone number and a fax number. So I will try to call, Kiki in my office will try to call, Kayana will try to call, Stephanie, after 4 or 5 times over the course of a few days, if we can't get through, we will fax a letter. This is also a case where we might want to reach out to U.S. Senator to say, okay, we're not getting any response. They've lost something. Things have gotten delayed. Can you do a congressional inquiry? I wish I could give you anything more than that. It's just, we've got a system where, Social Security is understaffed. They cut 30% of their staff. I have no earthly reason why. The people that they have left, the squeaky wheel gets the grease. They've got a lot of the people they have left manning the 800 number. When people call, they call in because they need a Social Security card or they got retirement issues. AARP is very big about that. So a lot of the people that are there are manning the 800 number. So, there's a lot of there's a lot of turnover, a lot of senior people. I'm not making an excuse. I'm just telling you the reality. It is a mess. And what we have found is that if you put it in writing, it gets into the file. So that's helpful. They do tend to respond to that. They sometimes respond to phone calls, but not always. But the best thing you can do ultimately is a congressional inquiry, because they will respond when a member of Congress, especially a senator, reaches out. So I know that Kiki or Christy in my office I know we were talking about your case just the other day, so I know she's working on that. But that's the way we do it. I mean, I'll call when I have time. I'll tell you, this week I have 4 hearings next week on one day, so I was really focused on that. I think I told everybody my daughter is like overdue, about to give birth, so I'm trying to get everything ready to go. So I'm every minute I'm covering. But yeah, if I have time, I'll call. If not, Kiki or Kayana or Stephanie will call. We will not drop it. We'll follow up on that. Hello from New York. Hello. That is a person I know. How are you doing? Hope family is well. Hope all is well. I know this is a difficult time. What does stage 4 of the 5 stages mean? What can you look for? Well, if you're talking, there are 2 things you may be talking about. There's something out there called the 5-step sequential evaluation process, which is what Social Security goes through when they evaluate a claim. That's one. The second thing is when you look at your My Social Security statement, it may say you're in stage 4 or 5. I don't think the 2 are the same thing. So I'm thinking you're probably talking about what you're seeing on your My Social Security statement. That is simply, I don't think it means anything, quite frankly. I think this is just an estimate as to where the case is at. I think it maybe means that the case has been, your file has been sent to an in-house medical specialist for review, which is the stage 4. Stage 5 is when the adjudicator gets it back. I think that's what that means. But the problem is we don't have it doesn't equate to a time frame. So you could be at stage 4 for 2 weeks, 2 months, 6 months. But it's better than being at stage 2 or 3. So you're definitely, things are moving along. But I think that what's likely happening now is a state agency adjudicator has sent it to a medical expert, and these are people that do this for Social Security. They're medical professionals, either doctors, sometimes nurse practitioners, sometimes psychologists. They do it to make a little bit of extra money. They review the file. They will not call you. They will not examine you. They review the file and they will report back as to why they think the case should be approved or not. And obviously, the bias in these, medical specialists is to find a reason not to approve you. They tend to overstate your capacity. A person who is, I look at this all the time, person who is 55, they could do medium work, like you got, herniated disc, you're going to be lifting 50 pounds, but that's what they do. If you're between 50 and 55, they'll say you could do light work, so you don't meet the grids. So again, they're looking for reasons not to approve you. Does Social Security tell them to do that? I don't know. But, every once in a while you'll have one that says, yes, this needs to be approved. The other thing they do, which drives me nuts, is they will say, yes, the case should be approved, but as of the person's 55th birthday or as of the date of this MRI. And they cut you out of past due benefits, which again is, part of the strategy of Social Security to reduce the outflow. I was talking to a client of mine today who got approved at either initial or recon, and a very deserving claimant, but they changed his onset. His original onset was age 52. They changed it to age 55, his 55th birthday, and it cost him, if we don't appeal it, $80,000. So we talked, and I said, look, we had a long talk. I said, look, my feeling is if we go in front of a judge, and I looked up the hearing office will be in front of, and the judges there are pretty reasonable. The likely the worst that's going to happen is they'll find you disabled at 55. You're in the same place as you would be. Is there a chance that you have a judge that says you're not disabled? Yes, there's that possibility, but you got herniated discs and you got, shoulder problems and you had a long work history. I think it's probably pretty unlikely, but, it could happen. So I said to him, I think my feeling is, 43%, they leave it at 55, 43%, 45%, they put it at, age 52, what we want, maybe 3%, whatever the math works out to be, 3% they deny you entirely. So are you willing to risk a 3% chance of being denied, which we could appeal, for $80,000? When, again, the most likely scenario would be either we win the earlier onset or an earlier onset, or we, keep things as they are where you're already approved. I think it's a pretty good risk, but again, I'm not the one who would be in an overpayment situation if we lost, if we did not win the hearing. I'm not the one who would be giving up ongoing benefits that have already been awarded. So, there's a judgment call. And my feeling, by the way, on those, if they change the onset date, and I do these analyses where I literally will do this, and it takes me a while because I got to go through and figure out all the numbers and the date of application and date last insured, all that stuff. If we're talking about $4 or $5, even $10,000, probably not worth appealing. We're talking about more than $10,000, $15,000, $20,000, $30,000. You got to give a good look at it. Sometimes I'll look at it and say, the medical is not really in your favor, so we should keep it the way it is. I'll give my opinion, but at the end of the day, clients have to decide. I had a guy that I thought should appeal, $100,000 he lost, and I'm like, there's no reason not to appeal. The odds of being completely unfavorable are almost nil. Didn't want to risk it. Okay, that's his call. But yeah, so I know I've kind of got off topic here a little bit, but the bottom line, stage 4 probably in your context means that it's being looked at by a medical specialist who, again, is not looking at it for a reason to approve it is looking at it for a reason to probably turn it down. But every once in a while they do get approved. Again, 15% of recon appeals are approved. 35% of initials are approved, but those are usually pretty severe cases. Annie Davis, how will CDR processing moving from the state DDS to the federal? It's the latest news from SSA without much details. Yeah, that I was just mentioning that, Annie, that the CDR processing is going to go to a centralized office. It's not going to be done by state. So that means you're going to have a group of adjudicators, in a central location, and their role is to do the CDRs. So I suspect we may see more consistency, but realize the goal of doing this is not to reduce the number of terminations. It's to increase it. Social Security wants to terminate more people. They feel like there was there are too many judges are independent. They feel like there are too many judges who are willing to approve people, especially on like chronic pain cases, depression, things that can't be imaged. I think if you've got an MRI, a case that can be imaged with an MRI or a CT or an ultrasound or a blood test, things like that, I think you're probably less in danger. But I think the cases where there's PTSD, severe depression, anxiety, fibromyalgia, CRPS, those are the ones that are going to be looked at more. I think people that are younger, if you're under 50, those are the ones going to be looked at more. So yeah, they're going to look to try to get people back to work, and they're going to try to get them terminated. One of the things just to be aware of it in the termination world, which is really unfortunate, is if they move to terminate you, which realize what's going to happen is you first get a form, either a 455 or a 454. The 455, I think, is the short form. The 454 is the long form. It could be, I could have that backwards. If they review it, and the long form in particular, and they see that there's been medical improvement, or they gather information, they see medical improvement, they will move to terminate. So getting the CDR form itself does not mean you're being terminated. It means they're looking at it. Let's say you send it back and they decide they're going to terminate. They will then send you a letter saying, we've decided to terminate benefits. We think you've improved medically. You're no longer disabled. Then they'll say this: if you want benefits, if you want to appeal it, you can appeal it. Here's the form. It's a reconsideration form, which is a very simple form. Excuse me. However, if you want to continue receiving benefits while you appeal, you can do that. You have 10 days to request that, and there's a form to do that. The problem is, if you request benefits to continue, there are no accrued benefits. So if you call a lawyer to say, I've got a CDR, I have benefits continue, I want to appeal it, there's no past due benefits. So the lawyer's going to say, well, I'd like to get paid for my work. Can you, write me a check I can put in my trust account? And, realize that in disability cases, which this is a full disability case, it's the same hearing and the same everything, attorneys are paid 25% up to $9,200, the average fee being in the $5,000 range. Okay. So if somebody calls me and says, I want you to handle a CDR, I may say, depending on the case, I need $3,500, $4,000 in my trust account, or maybe more, depending on the complexity of it, so that I can get paid. But, you're not going to find a lawyer to say, okay, I'll take that case, and if I win, you pay me. It's not going to happen. So it's a real problem that you're going to have a lot of people are going to be forced to make a decision. Do I have benefits continue, which provides me money to eat and shelter and go to the doctor? But that means I can't get an attorney. Or do I say, let benefits stop so I can have accrued benefits? I can get an attorney on a contingency, but then what am I supposed to do for food and shelter? So it really puts you behind the 8 ball if you do get a review. It's a very difficult scenario, and I don't know what the answer to it is, but just be aware that if you choose to have benefits continue while you appeal, you may very well find that you're not going to be able to get an attorney to help you. There are things you can do to prepare your case, but I'm not a big fan of somebody going in front of a judge without an attorney, but you may actually have to do it. Been thinking about some ideas about how, some unbundled services. I hadn't come up with exactly what I want to do, but there's some ideas percolating in my head because I think we're going to see more of this. So stay tuned. There may be some solutions on the horizon. Dennis, I've seen you here before. Dennis, okay, you got the short form, which is really like 7 or 8 questions. If you answer no to them, generally speaking, it's graded by a machine. You won't hear anything more. You're 58 years old, probably not going to be terminated. I mean, if you've worked and you've gone back to work, that could be an issue if you've got medical improvement. But again, you're starting to see Dennis is 58, somebody else was 60. We weren't ever seeing that before, the CDRs or the forms being sent out. Now we're seeing more of them. So I think that's a trend. That is a trend. Mailed in, and they don't give you any particular time frame when they're going to get back to you. It could be a couple of months, it could be a few weeks, it could be 6 months, which is also very, very stressful, to say the least, that you fill in the form, you send it back, and nothing for months and months and months, and you don't know, what to do. What I would tell you to do is assume the worst, and that you may be terminated, and make arrangements to, have friends or family help you with living expenses if you decide not to have benefits continue. And I don't know what to tell you. It's a very, very a difficult scenario there. Okay, Wizard says, doing CDR, have schizophrenia, POTS, which is a kind of it's sort of I guess POTS is the balance issue where your blood does not flow to the brain when you stand up quickly enough. And so people with POTS a lot of times have a really hard time. They have to stand up very, very slowly. They have poor balance and things like that. And then you've got schizophrenia, which is obviously a severe mental health issue. So you got 2 things going on, both the POTS and the schizophrenia. You're on SSI. They have 200 pages of records from the psychiatrist. They're sending me for medical exam, non-specific. So yeah, they're gonna, this is what they do, is they're gonna send you to one of their doctors. I will tell you, my experience has been that the psychologists they send you to for the consultative evaluations tend to be a little more reasonable, in my experience, than the physical medicine doctors they send you to. Not always, but that's been my experience, because the psychologists tend to be practicing doctors with real caseloads, whereas the physical doctors that do the CEs for physical medicine tend to be industrial clinic doctors who do a lot of work for insurance companies and are sort of paid to say no. But psychologists are not like that. So that could actually be beneficial to you to go to the, if it's a psych report or psych evaluation, if it's a physical one, I think bring medical records with you to show that you've got this ongoing treatment and the diagnosis. But yeah, it's a challenge. But I think you have to be your own advocate. You've got to be diligent about getting their doctors the information they need to evaluate. Hey, Christy. Okay, the CDRs. Yeah. Okay. So this is this other question about the national. Honestly, the only thing I know about it is they're centralizing the CDR unit. It used to be done at the state agency. You'd have a couple of adjudicators that were dedicated to CDRs. Now it's being done in one office or maybe a couple offices in different places in the country. And you will have adjudicators that's what they do. They deal with CDRs. And like I said, this change is not designed to make it easier for you to keep your benefits. This change is to make it easier for Social Security to cut you off. So, as a claimant, you got to continue to go to the doctor. You've got to be compliant with medical treatment. If you work, you've got to be very, very diligent about keeping track of the amount that you're earning versus the substantial gainful activity and trial work period numbers. And you've got to keep a symptom journal, I think, have other people that might be prepared, almost like you're preparing for a hearing on your own, as if you were going to another hearing. So, I think people get into trouble when they stop going to the doctor. They get approved, and then the doctor says, well, there's not much I can do for you other than surgery. You don't want surgery. And then so the doctor's like, well, there's nothing I can do for you. and you're on long-term pain management, you go in to a pain doctor or a nurse practitioner, 3 or 4 times a year to get your prescription refilled. You sort of have to have more than that. I hate to put it that way, but you got to have more than that. And it may mean going to the doctor and just, telling the doctor, I'm here because I've got to make sure that I'm looking as anything new coming out there. Let's talk again about the surgery. And you got to build a record. You want to make sure you have a paper trail showing that you're going to the doctor, you're being cooperative, and that you remain a surgical candidate, or you remain in long-term pain management. Cooperation from your doctor in the form of functional capacity evaluation forms, very, very helpful. But yeah, the centralized CDR process is designed to increase the number of terminations, not to benefit you. Okay, so this is the person who's got schizophrenia and POTS. Let's see, you sent your PCP and cardiologist. Should you be worried about this medical comprehensive exam being not specific? I mean, when you say be worried about it, I mean, it's something, anytime they send you to an exam, you want to be cooperative with the examiner, don't want to exaggerate. You want to be very matter of fact, but I would tell you, whether you're dealing with an adjudicator or a consultative examiner, be very, very specific, about what you can do and how long you can do it. Avoid things like not very far, not too much. Realize that they will be observing you, the doctor or somebody in his office or her office, from the time you park in the parking lot. They're going to watch you walk in. They're going to look at you in the waiting room. They're going to watch you walk into the exam room. And if there's a difference between the way you walk in the parking lot and the way you walk in the doctor's office, that will be noted in the report. So you want to be very, very straightforward. You don't want to come across as being overly invested in being disabled. You want to let the doctor know you'd much rather be working, and come across as being reluctant that you have to pursue this route, or that you're on this route, and that your desire is to work again. That can help a little bit, but you can't control the doctor they send you to or the report. And some of these reports I've been able to challenge. There was a while there where there was a couple of doctors locally who would literally, it's the same report except for the last page, and so I'd get 5 or 6 of them, and I'd submit that as like, hey, this is bogus. The other thing I do now is, if a client has a CE exam and they notify me, they call or email afterwards and say, I was in there for 10 minutes. I'll get the report and send it to them and say, is this what the doctor did? All these tests? No, that's not what they did. We'll put together a form SSA 795 where we'll basically write out what the doctor did not do and compare it to what the report says. So I would take notes in your on your phone right after you finish your exam, what actually happened. There's been some talk on the listserv about, can you have somebody else in there with you? Can you record it? And many of my colleagues say, yeah, you can bring somebody in with you if you want. You can record it. I know some CE doctors are not real happy about that. You risk upsetting them. That could work against you. But certainly there's nothing that says you shouldn't write down everything that happened afterwards. Or, if you have like on your phone or something, if you can put record on and kind of do it quietly. I mean, this is your exam. You could record it if you wanted to. I personally wouldn't have a problem with that. So I think you just have to just be aware that the main purpose here is to find a reason to cut you off. You got to fight back. The big TA. I was denied in late November 25 at 49, turned 50 in October. Denied because the ALJ had a hearing, said your RFC, or your functional capacity, was sedentary and you could do sedentary work, even though you have 4 severe physical impairments. Denied appeals counsel of attorneys filing through a federal appeal. My question is, would you go ahead and apply a new application now, let the process start, knowing the hearing will well past your 50th, wait until you're 50 to file the new claim? Well, I mean, I think you need to know when your date last insured is, certainly, because you don't want to file it. You need to make sure your onset date is before your date last insured. I mean, realize when you're not allowed to file a new claim while you're at the appeals council, but once you're in federal court, you can. Um, and I think what would happen if you win in federal court, it gets sent back, the cases will be consolidated. Yeah, you're going to obviously have a better argument at 50 than you did at 49. Should you wait until 50? The only reason to consider doing that would be to say your onset. You could certainly do your onset being the day after your unfavorable hearing. You apply now, and then worst comes to worst, you can amend the onset to your 50th birthday at a hearing. Let's look at the scenario. You apply to you file a federal court appeal. It is not successful. You've started a new application. You alleged an onset, when you were 49, because it's after the day after your unfavorable decision. You have a hearing. You're age 50 years and 9 months. The judge could award you at age 50. Of course, you have the 5-month waiting period, so you would get you might get 4 or 5 months of past due benefits, and you would get ongoing benefits. But you don't need to wait till 50 to apply, but you might eventually have to change your onset date. And I think you could also make an argument that if a judge found you limited to a sedentary RFC at hearing 1, you get to hearing 2, there is some law in some of the circuits that says another judge or the same judge can't say, no, now you're limited to light work. They're stuck with that sedentary impairment or sedentary level. So I would certainly coordinate with your lawyer, but I don't see there's any reason to wait to file, because the onset date can be changed. And if you're going to be at a hearing after your 50th, as long as you could change it to your 50, again, assuming your date last insured is in the future. Your date last insured's in December of 26 or 27 or 28, something like that, because you want to make sure your application, or your onset date your disability began, is before the expiration of your insurance credits, your date last insured. Okay, I know it was a little complicated there, but I hope that was helpful to you. Howard Flynn. I'm going to school full-time and only one class in person. Will it be helpful to apply for benefits from school to add to evidence for your claim? Also, does going to school full-time, mostly online, look bad? Yeah, I think it does look bad. I mean, I think that, SGA, or substantial gainful activity, is defined as, either A, earning over $1,690 a month gross. That's one way to do it. Or activities that are equivalent to a job that would pay you, $1,690 a month. Going to school full time, either in person or online, you've got to structure your day. You can't have too many absences. You've got to focus and concentrate. It kind of smells like SGA if you're doing it full time. So I think that, that you're going to have a burden if you apply for disability, that, why is your going to school not SGA? Now, your question would be, should you apply for disability from the school? So I guess you're asking me if the school has its own disability program and you're getting some special accommodation. I remember I had a client one time who had terrible vision, and they had a person come in who would literally take notes for her and read to her. That's an accommodation. The same thing as if you're at a job and you have somebody who's doing all the physical labor for it. It's an accommodation. That is not SGA. I had another client years ago, a very young woman, had severe scoliosis and was going to school, and her mother would literally have to drive her from class to class, even though it was a small campus, wheel her into class, and sometimes help her take notes. Again, that is an accommodation. So if you're talking about getting some sort of an accommodation from the school, that could reduce the danger that your school is going to be considered SGA. But generally speaking, going to school full time kind of looks like SGA. So you're going to have to get past that, and explain why it isn't. So it's got to be, something that's not like what another person going to that school would be doing. And nowadays in particular, a lot of school is done online, some in person, some online. So that's not the exception so much anymore. And that raises another, issue. I'll just throw it out just since we're talking amongst friends here. Social Security has really not done much in terms of figuring out how to treat people working at home. Um, at this point, I make the argument if you're not working in an office, you're getting an accommodation. If your employer lets you work at home, that's an accommodation. I think that's probably less and less accurate these days. I mean, I work at home a lot. What's behind me is not my house. It's a green screen. Um, that's a, it looks like a house, obviously, but I work at home. I have an office. I go in once or twice a week, check the mail, do a couple things, but I work at home. I just find it's quieter. I have a whole office set up. I got my computer, my 3 monitors, my office phone. I mean, I'm ready to go. And I just find it more comfortable. I can go upstairs if I want to, take a quick break. I can go lift some weights. I can do it. I just like it. My staff, they're all remote. Nobody comes in the office. So Kiki, who's in Texas, she's working out of her house. Madeline, who's in Oklahoma, working out of her house. Stephanie in Florida, working out of her house. Now not everybody can work out of their house and be effective, but many people can. So Social Security has not yet decided how they're going to treat that, but it wouldn't surprise me if there were some rulings that came down that talked about, not treating people working at home as being an accommodation. Hadn't seen it yet, but I think that's probably going to be coming down because I think, the workforce has changed. I think, a lot of people, now work at home. It's a, just a perk of the job. Now, I will say that, during COVID, it was, much more common. I am seeing more and more companies wanting people to come back to work. My next door neighbor is a real estate lawyer and his office was all remote. And now he's saying, yeah, we want people coming back. We feel like we're getting more productivity out of them. So, maybe it's not as common as it was during COVID, but it's still, I think it's still, something that Social Security is going to have to address. Let's see here. Okay. All right. My caseworker says all the medical records support my claim. What is next? The case will be sent to a medical specialist in the adjudication office. The specialist will review it. I was talking about these people before. They're not looking to find ways to approve you, but sometimes they do. And they will issue a report back. And I can get you a copy of that because we can see it, the explanation. If it's turned down, they'll explain why they turned it down. If they approve it, they'll explain why they approved it. If they approved it with a changed onset date, they'll explain that as well. And honestly, when I'm doing my pre-hearing briefs, I look at what these medical specialists wrote, and I basically argue in the brief, this is what your own doctor found, and I argue you shouldn't make it more, you shouldn't give the person more capability than what your own doctor found. So again, this is just, that's just my, I don't think they're required to do that, but that's my argument there. But yeah, that's what's going on. It's just being sent to an in-house medical specialist. Okay. And so Big Todd, this is the person who is 49. So since you did not have stroke in your right eye, which causes loss of vision, will that push it over approval for a 50? It could. I mean, I think that, one of the things I tell people is if you're going to reapply after a denial, something needs to have changed. You obviously have a loss of vision in your right eye. What does that tell me? Well, there are certain jobs, categories of jobs you can't do. Maybe jobs that require binocular vision, depth of field, driving a forklift, driving a van, things like that, having to judge distance, working in unprotected heights. I mean, working on dangerous equipment. There's entire categories of jobs you can't do. But are there sedentary jobs that do not require, binocular vision or good binocular vision? Yeah, there are. Is the stroke in your eye, is it distracting to the point where it interferes with focus and concentration? Is it painful, or you have to take eye drops that are uncomfortable, or that are distracting? I mean, do you have brain fog? I mean, there's a lot of things. Is there anything else the stroke caused? So, you have to explain the practical issues there. So yeah, that could be enough to push you over the edge. And certainly the jobs that the judge came up with at your first hearing, look at those jobs, look at your denial notice, are those jobs that somebody could do with, limited vision in the right eye. Maybe that gets rid of those jobs. But again, the vocational witness has a whole dictionary of occupational titles, hundreds and hundreds of jobs. And yes, are there jobs that are sedentary, unskilled jobs that don't require, great vision? Yes, there are. But there are fewer of those. And, maybe that there's enough to push you over the edge. I don't know, push you over the top. I don't know. All right, Tough Boy is 63. I'm not sure. Tough Toy, I'm sorry. Let's see, do you have a question before here? I don't see anything else. So you may, 63 in general is a good age, for disability, because again, if you've got physical impairments, you've got the grid rule, the 202 grid rules, which is 55 and older. You've got the significant vocational adjustment standard for transferability of skills, which is very, very helpful. Many times people at 63 have also taken early retirement, which means that the disability trust fund is not being drained as much. That can help you. So, 62, anybody from 60 to 63, I think anybody over 55 is got to, that's going to help. Over 60, 63, that's going to help even more. That's going to give you a bit of an edge, I think. Ann Miller. In recon now, if denied, will probably go into next year, DLI 6 months before 55th birthday, was denied at light, at initial going for sedentary. What job is safe to do to extend DLI? Well, that's a really smart question. And congratulations to you for asking a very, very smart question. I think that what we're getting at, what she's getting at is she's trying to extend her date last insured to the point where it goes beyond her 55th birthday. So if she has to go for a light RFC at age 55, she can do so. Realize that to get 4 credits in a year, it's around $9,000 in the year. So to get 2 credits, which would be enough, I think, to push you forward, $4,500. So, if you got a job earning $1,000 a month, that's going to be, or let's see, I think before I even get to that, let's go for trial work period. Let's go beyond before that. All right, so the trial work period is, I think it's 1,000, what do we got? 1,060, I think. No, 1,210. Okay. All right. So the trial work period is 1,210. 1,690 is SGA. I think if you were earning, less than $1,200 a month, that is well below SGA. That is even below the trial work period. That is not going to hurt you, in my opinion. Yet it's going to enable you, because it's a cumulative total, it's going to enable you to build credits. Because if you did that every month and you get, let's say, you're earning $12,000 a year, $13,000 a year, that's going to buy you all 4 credits for the year. So you could work and earn $1,000 a month, $1,100 a month. I don't think it's going to hurt you in terms of your disability case, but it will give you those extra credits that you are very smartly looking to get. As far as the type of job, I think, anything that if you're earning $1,100, $1,200, no matter what it is, it's not SGA. But yeah, if you could find something sit down, 3 days a week, that looks even less like SGA. So I think, the less physically demanding it is, and if it's not full time, that's probably better. But I think you could safely earn $1,000, $1,100, maybe even $1,200 a month without being a problem. And that would get you the extra credits and not screw up your disability case. So that's a very, very smart question. That's how I would approach it. And by the way, if you have a month or two where you get over SGA, that's not going to hurt you either. It's kind of the ongoing kind of thing. So if it's like, 6 months over SGA, that's a problem. But if you keep it, like I said, I would keep it around $1,200. I think if you do that, you should be pretty safe. My wife signed from OSO. My wife signed for Medicare Part B, but canceled it. She turned 65. Can she enroll again? Honestly, I don't have the answer to that because I don't know much about Medicare rules. That's just not my area. The person I would reach out to is Cal Hero. I've interviewed Cal on my podcast before. Just go to, he's got a website called MedicareMall.com, info@MedicareMall.com, and ask for Cal, C-A-L, Hero, H-E-R-O. Ask Cal that question. He will be happy to answer it for you. He's been very generous with his time answering Medicare questions. He is in the insurance business, I will tell you, but he'll honestly answer your question. I mean, he's a legitimate, he wants to help people. He does want to make money, obviously, but if that's not what you want, he's not going to push. He's not pushy. So I think he would be a good person to talk to. And he's been very helpful to my clients, is what I can tell you. All right. Heath N says, I'm in an SSDI since 2003. Okay. Started working part-time, earning under the trial work period amount. Turned 59. Now I'm nervous about continuing part-time work. I don't think it's a problem. I mean, yes, our CDR is going to increase. They are. You're under trial work period. The reality is, and Social Security does realize this at some level, it's expensive out there. And even with cost of living increases, most people that I represent, sorry about that. I'm getting my tennis buddies are texting me. I'm not even sure. I want to know why. It's expensive out there. Gasoline's expensive, rents, everything's gone up. People have to sometimes work to survive, and they realize that. If you're under SGA, which is 1,690, that's usually not a big issue even at hearings. Might it raise the question if you earn $1,680 a month, month after month, that you are suppressing your income? Yes, that would happen. If you're earning less than trial work period, you're even below, you're not even triggering that. I think you're okay. And if you were reviewed, which is unlikely at 59, this is the most I can do. And I did it because I needed to survive. They realize people have to survive. Now, the presumption is SSA is going to act with reasonableness and fairness, which we can't always assume. But, if you could, so I would say this, if you could afford to quit work, that's going to make it safer. If you can't afford to quit work, but you're under SGA, under trial work period, that's the next best thing. If you need to earn close to SGA, $1,400, $1,500 a month, that still technically doesn't mean you can work, but now you're starting to get close to the line. So that's what I would tell you. But I wouldn't personally stop working if you're able to do something. I think there is a benefit to working socially. You feel like you're contributing to your household. There's a, personal satisfaction, social element to it. So, don't discount those things. Working is a good thing for you to do if you can do it. Borakua 938. Good evening, Borakua. I hope I'm pronouncing that correct. Patricia Harding. I've worked for 38 years, ending up having a knee surgery at 58. Now I'm learning because of the surgery, I lose my 38 years. So my check will remain the same. I thought I would receive 2 checks. I'm not sure are you saying, did you think that you would get more money because you have a new medical issue? No, I mean, people, that's a pretty clear matter of law. If you were approved, let's say 5 years ago and you had a back problem and you're getting $2,500 a month from Social Security, then now you have a bad knee problem, which has made your condition even worse. You don't get more money. At the VA, you might, because they look at the individual medical issues and you get paid more percentage-wise for them. But in Social Security, it's an all or nothing type of thing. So when you say you lose your 38 years, I don't know what that means. Your check will remain the same. I don't know that you received. I'm not sure if I understand what you're talking about, the second check, but you don't get more money if your condition becomes worse. Just like you don't graduate from SSI to SSDI. If you're an SSI, SSDI is not like you get an SSDI because your condition got worse. You have to have the credits for it. But you don't get 2 checks for a decline in your condition. Okay, we already talked about that one. Oh, thank you very much. My pleasure. I'm happy to do it. And, I believe in good karma. I think that if you send good stuff out in the world, it comes back. And so I'm happy to do it. And I hope you find these live streams of my videos helpful. Actually, I got to do some more. I've got a bunch of them I've sketched out. I just hadn't had time to do them. It's just, you know, things get busy. Things get busy. And here's a link down here if on the crawl, if you find the live streams helpful, if you find the videos helpful, please leave me a positive review. That really helps build my practice. People are looking at Google and they're looking at Avo and they're looking at Justy and all these other places to see what people are saying. And having good reviews is very helpful. Other thing which I'm finding is that some of the AI tools like Chat GPT or Perplexity or Claude, they are looking at reviews as well. So the more positive reviews I've got, the better. So if anybody is so inclined, I would really appreciate it. All right. Boracua had triple bypass, 5 disc removes, fusion, rheumatoid, hearing May 21st, denied 2 times. Sounds like you got a pretty good case to me. I mean, you've got 5 disc fusion. Again, assuming that you've lost some flexibility, maybe there's some ongoing pain. I don't know. You've got rheumatoid arthritis. That is obviously painful. Triple bypass. I suspect you've got some exertional limitations. Again, you don't win on a diagnosis. You don't win because of past medical problems. What are the functional issues that impair you? And here, the functional issues might be, standing and walking and kneeling and crouching. I need to take a break during the day, exertional capacity, chest pain on exertion, difficulty, being in respiratory irritants because of the heart issue, the rheumatoid arthritis, swelling, problems with grip strength, problems with holding things. You could go on and on about all the potential issues you've got. You want to write them all down, all the potential problems you got, and why are these things limiting you from work? Because I can't lift more than 5 pounds. I can't, stand more than 10 minutes. I can't walk more than, 5 minutes, whatever it may be. You want to practice with your lawyer about those limitations. And by the way, that's an interesting conversation I have with my clients because, like, I was talking to a gentleman today who was had a very physical job. Hearing is coming up in a few days, and we're talking about what he can do. And here's a guy who sees himself as a truck driver. That's what he did. And he's basically, I can't go do that anymore because I had to lift 100 pounds and I was making deliveries and pallets. Now, very physical job. And I kept saying to him, I get that. You cannot go back to driving a truck and dealing with pallets. No question about it. The question for Social Security, though, is, are there other things you could do? And at his age, all I have to do is prove he can't do light work. Light work is standing and walking 6 hours a day, lifting 20 pounds occasionally. So if I can prove that's his limitation, we win because there's no transferable skills from what he's got. And I would say, well, how long can you stand? I can stand about an hour. Like, really? You can stand about an hour. You've got all these back issues. Do you think you could comfortably stand an hour? Well, maybe it's closer to half an hour. In other words, the more we talked about it, I wasn't trying to put words in his mouth. I'm just like, you really think you could lift, I could lift a case of water, about 35 pounds. I said, really? Do you think you could do that more than once? No, I could maybe do it once a week. I said, well, that's, I'm talking about what you could do 3 or 4 times a day. Oh, maybe about 20 pounds. The more we talked about it, the more, it kind of came out. And I think he didn't want to think of himself as being disabled. And so he's thinking about himself as being strong and healthy and young. And now he's got significant medical issues, but it's hard for him to kind of make that connection because he thinks of it as, okay, I can't do my past work, I'm disabled. Like, no, that's not it. But, it was trying to get him to understand, to really think about what he could do without telling him, don't say this, but I'm saying, you really think you could do that? Sitting, for example, I could sit for an hour. I said, you can sit for an hour. Your back you got disc herniations. You got all these things going on. Could you really sit? Well, in a recliner? Well, that's not the point. The point is, could you sit in an office chair? No office, no workspace is going to have a recliner for you. It's, could you sit in a hard chair? Oh, no, by about 10 minutes. Well, that's a big difference between 10 minutes and an hour and a half. So, trying to get that across. In fact, after our conversation, I emailed them. I said, "This is what you told me. So let's make sure that we use that if it's accurate." I said, if you can do more, then tell the judge the truth, but it's going to make it hard to win. But tell the truth. But this is what I think, what you're trying to tell me based on our conversation, and so this is just to remind you what you told me. So we'll see what happens in the hearing. All right, Dimple Bellamy, how are you doing, Dimple? Don't like the cold weather either. Ready to become a snowbird. There you go. I know in Ohio it can get rather chilly, so people from Ohio a lot of times will come down to Florida or Texas during the winter months. So maybe that'll be you at some point. But yeah, I don't know if I've been too many places in Ohio. I think I was in Cincinnati one time. I have a really close friend who's from Columbus. I've never been there. Cleveland, I've never been. I want to see the Rock and Roll Hall of Fame at some point, but I've never been there. Never been there. Okay. Geronimo Gutierrez. I'm 54 years old. I suffered a cardiac artery disease that is diffused. Have diabetes and ripped a rotator cuff. Already had a hearing. Now I have to see a post-hearing CE is what I'm guessing you're saying. Let's see here. What else we got from Geronimo? Anything about Citizens Disability? I don't know much about them. I mean, I don't know if they're a law firm or a non-attorney rep. I don't ever like to speak about people I don't know. I mean, again, Lindsay Osterhout, somebody asked me about, I know Lindsay. I know she does good work. I just don't know. I'm not going to say anything bad or good because I don't have any comment. I don't know anything about Citizens Disability. I think you've got a pretty good case there. You've got coronary artery disease, it sounds like, that is, not in one place. So it's, several places. So it probably doesn't, respond well to treatment. You may have been stented several times. Diabetes, which is going to complicate things. Rotator cuff is going to limit your lifting. I would argue probably the grid rule, the sedentary grid rule, and, maybe argue functional capacity as well. So I think you've got a pretty good case. The real question is, can you get approved before you're 55? I would say it's a pretty good argument, but, again, without looking at the medical, I can't say for sure, but I think it sounds like you've got enough things going on where the functional issues logically would arise, I think that would prevent you from working. Vince is from Michigan, Round Lake, Michigan, the Upper Penn. Got 52 inches of snow. Snow drifts over 20 feet high. 6 hours from where you live. We just got a dusting, lots of high winds. If anybody lives in Round Lake, Michigan, God bless them. I wouldn't mind visiting something like that. I wouldn't mind seeing that kind of snow on a visit. Because that, it's just otherworldly. But they obviously get a lot of lake effect snow up there. But, and I've heard, and maybe you can tell me, Vince, that it doesn't really start to warm up until May in Upper Penn of Michigan. So I don't know. I mean, that's pretty darn cold. Pretty darn cold. Okay, Dimple, my pleasure. My pleasure. I am happy to do so. I'm glad you tune in. I know you someone's going to Stephanie Joy's live stream on Wednesday at noon. Steph is a good friend of mine, and she does a live stream on Wednesdays at, I think, noon. I've been on hers before, and of course, she's been on mine. And I know Walter Knott does them as well. So there's other people out there doing them, and I think you should learn from as many people as you can. All right. Oso said I had to contact your congressperson to resolve an error. Pardon me, Vice Siska. I'm drinking these carbonated waters, so I apologize for that. Resolve in your favor very quickly. Yeah. So I think that, reaching out to your congressperson can be a really good way to get things moving and cut through the red tape. Okay. A direct phone number. Okay. SSA. Not lose my paper wasn't late. There's more of an internal issue. Yeah, they misplace things. This is just a function of the staff. I think it's just a function of the staff. It's unfortunate, but they do that. They just don't have enough people, and things get misplaced and misfiled, and trying to get them undone is very, very difficult. I was reading actually an article today about somebody who was put on a deportation list by ICE because of an error by a new staff member, coded the guy wrong or something, and he gets deported. And finally they figured out after he was already deported that they had something, they did it wrong. I mean, these computer systems they use can be unforgiving, and trying to get to that's the hard part about Social Security now, getting to a human being. It's just hard to get to human beings. They just are, they just don't have the time to really talk anymore. Heath N. Will SSDI recipients over 55 be negatively impacted because of the recent CDR working part-time making it harder? Yeah, again, we don't know. We don't know enough about the new process. Again, as I said before, it's not designed to help you. It's designed to terminate more people. I don't think it's designed to go after people over 55. I think it's really the focus is to get people that are younger, to get them off. Are people 55 going to get caught in that? Yes, possibly. But I just think that I would hesitate to tell somebody to stop working if it gives them money and some satisfaction. That's a judgment call you're going to make. But I've not seen any evidence or any even hearsay from my colleagues that working part-time below trial work period is going to cause you to be negatively reviewed. So maybe that will happen at some point, but I don't think so. Look, if they're going to review you, they're going to review you. And working and earning $1,000 a month is not going to change that, I don't think. The main reason they terminate people is because of medical improvement. So unless there's been medical improvement, it's not any more likely than it ever was. Okay. When can I get access to the file? Let's see if I've already got it. I usually get them pretty early. Let's see. Yes. Your file has been, okay. So your file has been worked up. We got a good judge, high approval rate. That's great. And the file has been worked up. I am more than happy to send you a copy of everything that they've got. Normally what we do, and your hearing is coming up in June. So, what's happening now in my office is Kayana and Paola and Kiki, they're working, I think, now in the May cases. They're starting to get these cases, updated, ready for me to do my brief. But I'm happy to send you, let me make a note of that. I can send you the file as it stands now, and that way you can look at it. And anything you notice that is missing, you let us know. But yeah, this is part of the process. We're getting close, but we got a great judge, so that's a good news. I'm feeling, just on that alone, I'm feeling confident. Based on your age and onset, I think we got a good case. I mean, I take good cases, so yours is one of them I took because it's a good case. So I continue to feel that way. Okay. My pleasure. Thank you. And I saw what you said before. I get that. We don't want to overshare here. Okay. Okay. So again, we've talked about this a little bit. I will see if I can find more about this. I know a lot of people ask questions about this. There is not much on the listserv. Let me see if NOSCR has anything about this. I'll find out and let everybody know. But so far, only thing we've been told from NOSCR at least is they're centralizing it. But what that means once that happens, I don't know yet. Okay, Mary Simmons. Hello, Mary Simmons. Okay. I don't know what section 221.42 USC for. We don't know what it's going to mean yet. I don't know why. Again, I don't know. I have to look that up. Why it would violate that. So I'm not going to do really good research here on during a live stream. But I suspect that if it does violate a statute, it will be challenged. But I don't know that centralizing decision making would violate anything. Social Security is an administrative agency, and they can centralize things. It's a federal agency. I don't know that there's law that says they can't. But again, we'll kind of see how that plays out. OSO's approved first time at 55, severe diagnostic, discogenic issues. So yeah, I don't think, yours is not the one they're looking for. Walter recently talked about a rule that had to do with complying with medical treatment that be enforced too. I mean, there's always been in the Social Security world a feeling or a expectation that you will cooperate with your medical treatment. That gaps in treatment are a problem because it shows you're being they call it being non-compliant. And, is it possible that in the CDR context, they may try to use that as a reason you are not compliant, you stop going to the doctor? I don't think that's anything new. Again, I come back to the change in the CDR rules are not designed to help you. Social Security is trying to preserve a trust fund. You and I know that you paid this money in when you were working with the expectation to be there for you when you got retired or you became disabled. That's the way we look at it because we paid the money. Social Security looks at it, it's their money, and they're going to not give it out to you unless they're forced to do so. Very different mindset. There is a trust fund. That money should have been set aside and for only this purpose. Was it? No. They saw money, Congress sees money, and they spend it. They build libraries, they keep post offices in remote locations, they spend it on wars, they spend it on all kind of stuff, or maybe not on wars, maybe they're not, Congress didn't do this one. But the point here is the money's been spent, it's an IOU, and they don't see it as your money. So the CDRs are designed to keep more money, not going out to you. So that's what the whole point of all this is. And any argument they can make to show that you're no longer deserving, even if it's by omission, meaning it's not that something you did, it's something you didn't do. What's the point if you have an orthopedic problem? And as I was talking to a client today, doctor said, yeah, we could do a fusion, but it's probably going to make you worse. It's not going to help you. There's no reason to do a surgery. So they're not a surgical candidate. They're a long-term pain manager. The orthopedic surgeon said, no reason to come back to see me unless there's a real reason to do so. Okay. They don't go back to the orthopedic surgeon. They see a nurse practitioner for pain management twice a year, once a quarter. Okay. Social Security comes and says, you're not going to the doctor. Your response is, there's nothing the doctor can do for me. You're not going to the doctor. You're not being compliant with treatment. We're going to cut you off. That's the danger. That's the danger. So almost to play their game, you have to, whether it's your family doctor or an orthopedic or a psychologist or whatever, you almost need to go, even though they can't do much for you. It sounds ridiculous, but almost you have to do that. And this is the same thing with insurance companies. You got to play the game. Got to play the game. And it doesn't make any sense. It's a pain in your rear end, but this is what we got to do. And I've had enough cases over the years where I had a client who was clearly disabled. Doctor couldn't do anything for him. There was no insurance money. Couldn't afford to go to the doctor. There's a 3-year gap in treatment. The judge is like, well, you're not going to the doctor. There must be nothing wrong with you. And so this is what you got to deal with. This is what you got to deal with. All right. Tenbros says, if you have mental disability, keep your therapy. Absolutely. Just going to that weekly, twice monthly, once a month therapy, group therapy, whatever, shows that you are being compliant. That's the key. Got to be compliant. Got to be compliant. And you got to keep your, take your meds. If your doctors are prescribing medications to you, you have to take those medications as prescribed. And if you're not taking for some reason, you need to explain why, side effects, whatever. But yeah, if you don't take the medications, you don't make the appointments, you don't go to physical therapy, you're just sitting at home because there's nothing much they can do, and physical therapy is uncomfortable and the meds make you feel all loopy, absence of treatment is presumed by Social Security to mean absence of problems. Okay. Shani Sweets. I'm under 50 on disability for multiple conditions. My last review was approved in 24. I was not told when I'd get another one. Any guesses? No, I just don't know enough about it yet. We just don't have any information about the new system. I will find out for everybody because I know this has been a very hot topic tonight. Let me see if there's anything on the NOSCR listserv, just even today. Let's see here. Plus CDR. Anybody has anything to say here? No, there's really nothing coming up on the new. Nothing new. So we just don't know yet. It's just that they have not switched to the new system yet, and so we don't know if there's what changes there will be, if any. But we'll find out, and I will let everybody know. You record. That's smart. I think it's smart to record everything because nowadays there are tools. I've got one over here. You can buy that you can record things that will make using AI a transcript. In fact, I'll tell you what I do now is I use something called Plaud, Plaud, which is a little device that looks like a credit card, and there's a web application along with it. We're not allowed to record the hearings. When you go to a hearing, the judge will ask you to confirm you're not recording the hearing. But the day after the hearing, I can download the official recording. So what I do is I take the official recording, I upload it into the Plaud app, and I ask it to do a transcript, and I ask it to do a summary. And it's very insightful to kind of hear what went on. And you can ask the AI engine, questions. Why did the judge, what was the judge's purpose in asking this question? Or, what do you, did the claimant, how did the client describe his back problems? And what words did he use? And I use that to sort of help me work with different clients about what you need to say. So if a client, resorted to not very much and not too far, I'll see that in black and white. So I'm asking questions of this. It's just, learning from what happened at hearings to try to make it better. So that's what I do. But yeah, I think Tenebraus recording everything is not a bad idea. Okay. And this is I think the AI component to it as well. Brian Konoski, who again is an appeals lawyer, and he's very big into AI, as I am. I'm using AI, all the time now. I mean, just to do medical summaries and to draft briefs and to do analysis of medical records and things like that. It's all, by the way, closed, so I'm not using nothing that's open to the public. Everything is HIPAA controlled and all that. But Brian made the point that the government, the Social Security Administration, is using AI to do analysis of claims. My prediction, and Elise Enton, who is a former Social Security employee, and she was my guest a couple of weeks ago, she said that as of the time she left last year, their AI system was very, very rudimentary. It was not very robust at all, but it's going to get better. I'm telling you, 5 years from now, 10 years from now, most of the original adjudication being done, it'll be run through an AI filter. There will still be adjudicators, but Bisignano, the new chairman of Social Security, the commissioner, he's a big believer in automation. And so what I foresee happening is claims will be developed by adjudicators, medical evidence. They'll run it through an AI tool that will be designed to ferret out the ones that should be approved. The ones that should be approved will get approved, and the other ones will be given scores. They'll use a scoring system. And, let's say the scoring system is 1 through 100, and to qualify, you need to have an 80. There'll be a scoring. They probably won't release it to us, but your case will be scored. And depending on how it's scored, depends on, whether they send you out for a CE or depends on what forms they send you out. And then judges, when they do their hearing prep, they're going to run it through an AI tool. It's going to become reality. I'm just telling you. I mean, it's not science fiction. This is what it's going to become, because what will allow them to do is reduce the workforce even more. Have one person doing the work of 5, because AI is going to do a lot of the grunt work, and analysis there. Instead of having somebody read through 1,000 pages of records, you're going to have an AI do it in 5 minutes. And that's what I use it for. I mean, there are, it's amazing. It really, truly is amazing. And I've worked really hard on my prompting that, I can say, one of my prompts to a medical record is, summarize this record to 3 or 4 pages. And it's not perfect, but it gives me a big picture idea. And then when I go into the actual file, look at it, I'm targeted. I'm looking at it targeted. So really saves a lot of time. It makes me more accurate. And I know people who've just, if you get an AI brief and they just submit it, they're a fool because, the mistakes will be there, but it does save time. So Social Security is going to use it. Yeah, I mean, this is about the CDRs. It's the reality. I'm just telling you, it's reality. Okay. Michael Dean, a decision's been made that was sent to federal quality review. Don't know the decision. They're required to review 50% of approvals, but 1% overall. This makes no sense. Been 8 days now. The quality review is somewhat random. I would say of the cases that I've had that have gone to review, I can only think of one time when it was reversed. It could happen. This is the review typically at the administrative level. But again, we can't control it. So if it's reversed, it's reversed. I remember I had a case probably middle last year where my client did not know his case had originally been approved and went to review, and it got sent back to the adjudicator. And he was not happy because I said to him, your case was approved, and then they went to review and they undid it. And he was beside himself. Like, how could they do that? And, like I said, Social Security sees it as their money. So, all right. Shani says, I'm in constant treatment, hospital stays. They're waiting underage people. Yeah, that is the primary target, is people under 50. It really is. But not everybody. Look, not everybody under 50 is going to get terminated. I mean, a percentage will, but if you go into the doctor, you've got significant problems, you're still going to be just fine. Let me change the banner here to my case eval. Look, there's people, if you're disabled, you're disabled. And, if you've got significant medical problems, they can have all the procedures they want. But at the end of the day, if I can prove that you are not able to work and I've got the evidence I need, ideally objective evidence, and you testify appropriately, we're still going to win. All the changes in the rules and AI and CDR, that doesn't change the reality that some people have medical problems that prevent them from working. And I would also go so far as to say that the work environment out there, no matter what you do, is more complicated. There's a thread on the NOSCR forum where some people say, and I don't disagree, are there really any unskilled jobs? Larry Rolfing is a very well-known attorney, very aggressive questioning of vocational witnesses and so forth. His take is basically there are no unskilled jobs. Every job out there requires skills, requires training. Even a simple, you're sitting on an assembly line watching things coming down a conveyor belt, there's computers that are involved in that. You may have to press a button to stop the line. There are things you got to know. Many employers want a high school degree now, or they may want, a certain amount of vocational training. So are there truly unskilled jobs? Yeah, but a lot of jobs, that used to be considered unskilled are not unskilled anymore. In fact, one of the things that the Social Security has had to deal with recently, or not that recently, over the last several years, is the DOT, the Dictionary of Occupational Titles, which is the resource they use to identify jobs. You can look at it at occupationalinfo.org, occupationalinfo.org, that the DOT, there's a bunch of jobs in there that are called unskilled jobs, and they have basically, Social Security has recognized that they are not unskilled. They are skilled or semi-skilled jobs. And so they're telling vocational witnesses, you cannot cite to these anymore, or these jobs don't exist anymore. The labor market changes. And I'll give you the example. I've probably given this 10 times, but I'll give it one more time briefly. There's a job in the DOT being a copy machine attendant, where basically you take papers and you stick it in a copy machine and you make a copy. Okay, unskilled job. You could be, high school student, elementary school student, and do it. The problem is that nowadays, and I can speak to this from my own office, copiers are scanners. I mean, you can make copies of things, but many times you're scanning them. Many offices are paperless. So what do you got to do? You got to know where to scan it. So there's, it's a pressing a button. You got to know what button to press. And it may be one of 15 or 20 buttons. At my office, we have, maybe 10 or 12 destinations. And sometimes you got to choose 2 or 3 of them. Maybe it goes to my paralegal and to the mail person. Maybe it goes to me and to my wife for some reason. I mean, it just, or the accountant. It can be any number of things. So then you scan the document and it comes to your email address. So you've got to know how to operate email. You've got to be able to go into the email. Then you've got to be able to download a document from your email. Okay. Believe it or not, that's a technical challenge. Some people have a hard time doing that. What happens if there is a spam block on your email and it doesn't come through? You got to figure out how to deal with that. Okay. Or if it doesn't come through at all, like my copier, sometimes we have situations where, it gets jammed up and we have to reboot the copier. It takes some skills. Then you've got to know if, let's say you get it, you have to have an email address. You've got to have access to a computer, log into the computer, go into the email, you download it, then you got to rename it typically and save it in a directory. Okay, that's not an unskilled job, my friends. That's a semi-skilled job. That's 5, 6, 7 steps to make to save a document that you've copied. Not an unskilled job anymore. So if a vocational witness says, copy attendant, unskilled job, I'm like, excuse me, isn't it true that many offices are paperless and that they've got that's in fact a scanning job and that there's 5 or 6 steps like I just talked about? Well, yeah. So this is really a semi-skilled job. My point is there are a lot of jobs like that on their face seem to be unskilled, but in fact are skilled. Even, cashier jobs, maybe you have to make change. You got to know how to deal with currency or credit cards. You may have to charge differently for credit card versus cash. You may have to know how to log into something and re-log in if you lost your connection to the terminal. Call tech support. I mean, there's a lot of things. So my point here is, I don't belabor the point, but unskilled jobs, are there really any truly unskilled jobs? I don't know. I don't really think that there necessarily are. So my point here is that yes, the CDRs are probably going to get more numerous. They do make it difficult to win. But at the same time, remember the definition of disability has to do with your capacity to function in a work environment, and work environments inherently, by definition, are getting more complex and more complicated. So, if you're trying to prove that you're disabled and you've done one job over the last 15 years, how likely is it you're going to be able to get retrained? Probably not very likely, especially if you've got a high school education and you've done one thing. So there's also some positive things for the disability world out there as well. And that's a big one there, I think. Chan Tet. Chan is here every Wednesday, and I am glad to see you again, and thank you for the kind words. Terry W., 61 years old, has 100% to the VA. I'm eligible for SS disability. Been told yes. Being 100% VA disabled does not make you automatically disabled for Social Security. It would put you to the front of the line. You'll get a faster adjudication. The VA, despite the fact it's a federal agency, has a different definition of disability than Social Security. The federal retirement system has federal disability retirement system has a different definition. So it's taken notice, it can help, but it's not binding. And I've had a number of people 100% disabled, but the VA are not disabled by Social Security. But it does speed things up, and it does help a little bit. Steve, does chiropractic hurt your case? Don't get adjustments, laser, electrode, traction table therapy. Steve, my feeling on it is this. Chiropractic is a alternative medicine. It is not considered Western medicine by Social Security. There is a list of what they call acceptable or approved medical sources. I think they call them AMS or AMR or something like that. And chiropractic's not on there. Neither is acupuncture or naturopath. There's a bunch of them, that are not considered that. So a diagnosis by a chiropractor will not carry any weight. At the same time, judges will note that you've gone to a chiropractor. It does show you're seeking some sort of therapy. Again, electrode, traction table, things like that. So in the sense that it shows you're getting ongoing treatment, it can help. But it's, almost like if you're going to a massage therapist or physical therapist, and even physical therapists are given more weight. The big issue with chiropractic is if your chiropractor says, I think you have, radiculopathy, that diagnosis will not be given any weight by Social Security. But the fact that you're going you are given credit for that, if you want to call it that. So that is not a bad thing. And the important thing of making you feel better, the argument you can make is, and I think I would say, if it makes you feel better, that's a good thing, because maybe you could argue, well, that's going to help me improve my chances of going back to work. So that's one thing. The second thing is that if you're going to a chiropractor or non-approved medical source, also go to a medical doctor. Go to somebody who is approved, so you have both. And many doctors, I've seen orthopedic doctors talk about, with favor, that their clients are going to chiropractic and they're getting some benefit from it. And many doctors sort of see it as kind of like a form of physical therapy. So let your doctor know, but go to both. I wouldn't go exclusively to chiropractor, is my point. How is the CDR process? Again, the biggest change is they're moving it to centralized, but there's not enough information yet to say anything more. And so Steve has stenosis, disc disease, sciatica. And again, these are reasons why chiropractic, non-invasive, could be helpful for some symptom relief. But ultimately, that MRI you've got that shows stenosis, an orthopedic consultation, which talks about radiculopathy or possible surgery, is going to carry more weight. The pug lover here, first time here. Why would a chiropractor be bad if it's in your disability? I have one who also does acupuncture, work with my pain doctor who retired. Yeah, again, a lot of chiropractors work with pain doctors. It's just because they consider it to be a non-standard treatment. And, the AMA, the American Medical Association, is a very powerful lobby. And they discourage non-medical treatment from being given weight in federal government determinations. That's one factor. And I think chiropractic is also, I will say this, and I say this with all respect to chiropractors. I've been to chiropractors before. I think chiropractic can make you feel good. I've gone to a chiropractor and felt much, much better. I will say this, having taken depositions years ago, some chiropractors, not all, some of them maybe overstate what chiropractic can do. I've seen chiropractors talk about that chiropractic can be an alternative for your family doctor. And it can be an alternative to vaccines. Not all of them, but some of them, really are big believers in the natural healing process of the human body. Chiropractic, one of the premises is that by getting your body in alignment, it will heal itself. And I think there is some truth to that. But there are also some impairments in your body that are not going to be, cured by aligning your body. If you have a virus, a chiropractic adjustment is not going to help you. I remember years ago, and again, Georgia is kind of unique. We used to have this no-fault system, but there was a chiropractor that I ran across one time who was giving adjustments to 2-month-old babies. So there are some, like in any profession, lawyers included, that maybe abuse the profession. So I think that maybe Social Security feels like that there's pressure from the medical establishment not to give it weight, and B, that there is some perception that, just like there's a perception that people are faking disability, that chiropractors are overstating what they can do and that they don't want to rely on that. So that could be the reason. But, if it helps you, go for it, but get your medical doctor in there as well. Okay. Madeline, Madeline, hope you're feeling better. Madeline works in my office and does a lot of intake work. Has been kind of fighting a bit of a, I don't know, like sinus infection. Sounded a lot better today than you did a couple of days ago. So I'm glad to see that. But thank you for tuning in, Madeline. And Madeline does a really good job. So anybody who's talked to her knows that. Can I handle? Yes, I do cases all over the country because it's all done by phone or video. I have hearings coming up next week in Texas, in Michigan, Florida, and California. I've got one in California. In fact, I talked to my client from California today, the truck driver in California. So yeah, I do cases in California all the time. Spencer, okay, Bensmall. I recently got approved for disability at 57, got a 5 to 7 year CDR. It just means that in 5 to 7 years, when you're 62 or 63, they may look at your file. That typically, and the reviews are going to be 1 year, 3 years, or 5 to 7. 5 to 7 means they're probably not going to review it. But they have to put, and I don't know where you even found that, where they were going to give you a 5 to 7, but it means it's because you're so close to retirement age, there's no point. And there's so many ways to prove you're disabled. It's no point. 1690 is a month. That's the SGA figure. It is gross earnings. That's before taxes. Gross earnings per month. So realize if you're working and you're getting paid every 2 weeks, they're going to be like 3 months. You're going to get 3 paychecks. It'll take you over SGA. So it's 1690, and it changes every year. But in 2026, $1,690. Gross income per calendar month, not when you earn the money, when you got paid. So if you earned it in February but got paid in March, it counts to March. My daughter receives SSI. What does that count as my income? In terms of your own SSI, it's household income. There's something in the SSI world called the deeming, DEEMING, the deeming rules, and they look at household income and assume that other people in the household are buying food or paying for rent or things like that, and they credit some of that, or they count some of those earnings against you. That's what the deeming rules are. You are very welcome, Patricia. I'm happy to do so. Tina, how are you doing? Sent all my medical records to Madeline. Good. Look forward to working with. Yes, very much. Okay. And Madeline, actually, there's no E on Madeline. She spells it Madelin. I'm sure people misspelled her whole life. She can tell us. But Madeline is, like I said, she gathering medical records, and we spoke today. I'm not sure if it's about your case or not, but I know she puts them in a location where I can review them, and then sets up the files in we use something called My Case, which is like a case management system. So she gets all gets that all set up. Yeah, medical records. I used to drive a tractor trailer for about 30 years. Pardon me. And by the way, that actually can help you as well. Because if you've done something for 30 years, the odds of you going into an office job, not that great. And there's actually a ruling or regulation that says if you do strenuous physical work for 30 years, it's assumed that you're not going to be able to transfer into something else. So there is I think it's a regulation, a POMS regulation. And I put that in brief sometimes if I have somebody who's been there for 30 years or close to it. My first application is at the federal now. I'm 54, 100%. 100% mental health. This was my first app. New app was all that submitted to DS Step 3, asking for some forms. What happens if ... I'm approved in the new app with worsening conditions. So I'm thinking here that you filed your first application. It's now at federal court level. You filed a new application. And what happens if your new application is approved and the old one? So what will happen is the old one will be remanded back for a hearing on the time period between your original onset date and the time you were approved in your new application. So you'll basically be going for a closed period of benefits. Cynthia, how are you doing, Cynthia? Good to see you here. R. Wiley. Okay, so yeah, you're just approved. Like I said, I think you'll just be going for that closed period from the prior application to the date you're approved in the new one. Bear Borcua, yes, that helps a lot if your doctor supports you. That's great. That is very helpful. You have, I think, sedentary level functional capacity. That's helpful if you're over 50. Absolutely. Yes, Madeline is correct. 1690 a month gross income. And realize that's, gross income is before taxes. Now, if you have expenses that you have to pay that would allow you to work, medically necessary expenses, you have to rent a wheelchair. Well, that's not a great example because wheelchair is a different story. But let's say you have to rent a monitor and it costs you $75 a month so you can see better. Or if you have to have a special chair, a bariatric chair, or special cushions, and you're having to pay money for that, that would come off the top. So that would not count towards your 1690. So it could be a little bit more. Where I see this most often would be if someone's driving, let's say they're driving Uber, or they're driving something, and they've got to pay for their own fuel, tires, car maintenance, then those expenses would reduce the 16, that would be something that it's the 1690, after you've already covered those expenses. So if your gross income was, let's say $2,000, but you had, $500 in monthly expenses, then that would come off the top. And now you're at $1,500, you're below SGA. You are welcome for my help. I'm happy to do it. The Rock and Roll Hall of Fame isn't worth the trip. Go to Canton instead. Okay, so Shub is always a contrarian. He doesn't like the Braves. He's always giving me a hard time about my Braves here. Says the Rock and Roll Hall of Fame is not worth it. Does anybody else gone? I've heard good things about it. Canton is the Football Hall of Fame. I would like to go to that as well. And so I suspect if I ever get to Ohio, that will be, and I'm not sure how far Canton is from Cleveland. I've actually heard Cleveland's very nice. I've never been there, but so we'll see. I'll do my due diligence. I'm one of those people that, like, when I plan to go someplace, I will research the heck out of it because I just like to. I don't like to just pick up and go. I'm not spontaneous in that regard, so I'll check it out. But I grew up in the 70s and 80s, and a lot of the music that was even the 60s. I really enjoy that kind of music. And so I think it would be kind of cool to see, guitars and, handwritten lyric notes and things like that from some of the people that I listened to when I was growing up. So, we'll check it out. But Canton, I think, would be very interesting because football, and I actually would like to go to see the Baseball Hall of Fame as well, up in New York. So yeah, there's definitely some things on my bucket list haven't gotten to. There's actually the College Football Hall of Fame is here in Atlanta. I've never been, but I've heard that that's supposed to be really kind of a cool thing to do as well. All right, Appleton Arwally received 27 inches of snow, third highest on record. Yeah, I'm sure. Actually, I have a cousin who played for the Appleton. Used to have a White Sox, I think it was a AAA team, baseball team. And I had a cousin who annoyingly got all the athletic talent in my family, and he played pro ball many years ago. And he was in Appleton with the White Sox farm team in Appleton. One of my memories growing up was, and he's older than me, about 15 years older than me, and the White Sox had a rookie league team in Sarasota, Florida. And when I was about, I don't know, maybe 10 years old. No, it was less than, I was probably 8 or 9 years old. Went down there, my parents, and I got to be a ball boy at a rookie league baseball game, a professional baseball game. And so my job was to bring, the balls out to the umpire. And the other thing I did was if the ball was hit off the net, behind the plate, I would have to go fetch it. Because again, this is not, major leagues where they would have, they go through, I don't know how many baseballs during a game, they would reuse them, but I'd have to go get them. So I remember one time, I don't know why this sticks with me, but the ball gets hit off the net and it goes way up high and it rolls down, and I caught it. I got a big hand from the crowd. I'm like, this is like my moment of fame here. But yeah, those were, I remember that very well. But I remember my cousin had played in Appleton, didn't get up there to see him, and then he ended up not playing professional baseball for a career. He had some injuries, and there was a baseball strike, but he ended up doing pretty well for himself. He's done quite well for himself. Big import export business. But yeah, that was a very interesting time. But yeah, that's when I think of Appleton, I just think of the White Sox farm team up there. Okay, so Ross takes objection to what Shub says. It is worth the trip. Suggests exploring the Cahoga National Park. Absolutely. I'm a photographer, like to take pictures, and that would be something that would be a good photography trip. I have some buddies that would like to do that with me, and that would be kind of cool to do. And Vince tells me, yes, the Upper Peninsula has very long winters, spring weather on mid-May, and usually get snow late September. Yeah, you can have it, man. I don't want that snow. Okay. Let's see here. Is working as a real estate agent hurt my case? That worked about 4 years. It's a good question. I mean, I think that if you're doing real estate work, but you're really not making any money, it's not like you're doing it on a day-to-day basis. If you have your license, like I was talking to a client the other day who has a license, I think it was a woman, and she said, I've got my license and I've done a few deals for family members and I've made a little bit of money, but I don't advertise it. I don't do it for any third parties. In 15 years, I've sold 15 houses, all for family members. I don't see that as being SGA. If you're working 5 days a week, 7 hours a day, that kind of looks like SGA. But if you just got a license and you occasionally get a listing or you show a property, the question I would ask is how much time did you spend on it? And if it's just a few hours a week, not a problem. All right, just got time for a few more. Should I take Social Security at 62? That's a question way beyond the scope of what we can talk about here, because it just depends on a lot of things. Your life expectancy. I think your break even, most of us, the break even point's in the early 80s. Do you need the money? Are you applying for disability? I mean, there's a lot of factors that come into play, and that's there's claiming strategies. It just really depends, and there's no one size fits all there. Cleveland Clinic will not let you see the pain management doctor. You see the doctor once, they make you see the physician's assistant. Ask the doctor, get told this is how they do it. Again, a physician's assistant is considered an acceptable medical source. So, that's not a problem there. But, what you're saying here is that, you don't think it's fair. And I hear you on that. And I will just tell you, the medical profession has changed dramatically in the last certainly 10, 15 years. I think that, many practices, it's more common to see nurse practitioners, physician's assistants. Doctors are really subject to insurance company policies, and the insurance companies only pay them for certain amount of money for certain tasks, and they can't afford to spend time on things they're not getting reimbursed for. And that's just the reality of it. I mean, the insurance companies have a lot of power in this, and so they force doctors to reduce what the services they offer. I mean, you've probably heard stories about people that are trying to get a drug approved that is the drug to treat their condition, and the insurance company requires them to go through 5 other ineffective drugs before they'll approve that one. Or they won't approve a procedure because it's experimental, even though it could save their life. A lot of medicine's insurance company driven, and I suspect that's what's going on at the Cleveland Clinic. I don't know for certain, but I think it could be. Okay. Let's see. Okay, I'm a target group. Okay. Let's. All right, let's make this the last one because we're at 2 hours, and I need to. Like I said, we could get a call in the middle of the night that my daughter's in labor, so I gotta get to sleep here. All right, I wonder the difference between the 2 separate FCEs. One early said I was able to work a desk job, And a recent one says, I won't be able to compete in the previous job or any job in the market. When you say FCEs, do you mean the forms that are, did you actually undergo an FCE exam? Is it a form by a doctor? Are you talking about something different? So an FCE is a functional capacity evaluation. So let's assume you're talking about having an actual functional capacity evaluation by either a doctor or a physical therapist, a formal FCE exam. If the first one said you could work a job, and then the most recent one says you can't, then there's obviously been a change. So in a disability context, a judge is going to look at it and say, well, before the first one, you were not disabled. And at some point between the first and the second, you became disabled because you can't do any job. So the question is identifying when. Obviously, you can argue, that the first one was not entirely accurate. In fact, it didn't take into account pain. It didn't take into account things that were not physical, whatever it may be, and that I should be considered to be disabled, okay? Or I can accept that the first one did not disable me, but literally the week after that one, things took a turn for the worse. I became disabled then. Some judges would say, I'll find you disabled as of the date of the second one. So your job, your attorney's job would be to push back that date back as far as you possibly can. And believe me, I've had cases where FCEs say that somebody's not disabled, but I can argue they didn't consider things that were not part of that exam. For example, medication side effects or depression and anxiety. If it's purely based on physical, maybe you could do sedentary work, but when you factor in medication side effects, when you factor in depression, anxiety, or you factor in, GI symptoms, having to go to the bathroom all the time, we were able to get past that. So, look, the part of lawyering in the disability world is to make those arguments, and judges aren't going to always accept them, but sometimes they do. And to make the argument, because again, you have lived this as your attorney. I've not lived it. You lived it, and you got to tell me, or you got to tell your attorney, what are those things that prevent me from being reliable at a job? The medical is going to be a big part of it, but the medical doesn't cover everything, because sometimes, doctors don't ask questions, or you're not seeing all the doctors. You're seeing an orthopedic doctor, but you're not seeing, he doesn't know what the psychologist is saying, doesn't know what the cardiologist is saying, or the GI doctor is saying. So you got to put it all together. And that's kind of what lawyers do, is we put it all together, make an argument. I like to do it in writing in a brief, but you can do it verbally as well. But that's basically how that goes. So, all right, we are at 2 hours. I'm going to go ahead and end this now. I appreciate everybody tuning in. I hope you will all come back to see me next week. We'll see, what happens on the baby front, but I plan to be here next week. And anybody has any questions in the meantime, you've got my contact information down below. If you're one of my clients, you know how to reach me. If you're not yet one of my clients, want a case eval, please click there. And I hope everybody has a really great, healthy rest of your week and weekend. And I will see you all next week. Thanks a lot. Bye-bye.